Court does call the case, People versus Dion Richmond.
Trevor Maybach for the people.
Alexis, am I appearing on behalf of Mr. Richmond? Your Honor, I am requesting an adjournment today. Mr. Richmond was recently extradited to Ohio. He is in the Columbiana County Jail currently in Lisbon, Ohio. I did speak with him today, but I don't believe that there was a writ prepared for his appearance.
Right, but if he was extradited from Michigan to Ohio, I'm going to assume, looking at this charge, that charge is probably more serious.
It is, Your Honor. I believe it to be a failure to register allegation, where I've been in touch with defense counsel relating to him having an upcoming court date there on 10/17. I'm optimistic that we can resolve this in between now and then if we could be adjourned to a date after that.
After 10/17.
Yes, sir.
Okay. Preliminary examination will be adjourned October 21st, 2025. 9 a.m. That's before me. Bond continued.
Thank you.
Court does call the case of the People versus Jimmy Lee Murray.
I'm Roger Green for the defendant, Your Honor. We're ready to proceed.
Your Honor, this time people would request an adjournment, a couple reasons. One, case number 25 FB 1371 FY. That case is charged incorrectly to my belief. I don't believe we can proceed. We could proceed on count 2 because as it's charged, it was not illegal on July 2023.
Pardon?
Count 2 were abandoned.
On that case.
On that case.
Okay.
I did speak to Mr. Green, informed him of my intention to add a count 4 on 25 FB 2 FY, that being weapons, firearm possession by a prohibited person, because on that particular date it was illegal, I believe, for.
Well, why aren't these cases charged right? I mean, this is like a serious, and I don't mean to necessarily get on your case, but this is like the 4th or 5th case that I don't have the charges right.
Don't have a satisfactory answer, please.
Fair enough. Maybe I just need to say it out loud.
I'll pass it on to.
All right.
Additionally, I was going to be able to start the exam, possibly get through it on 25 FB.
In a twist straight out of legal drama, Dion Richmond's case highlighted just how tangled multi-state charges can become. Police Scarlight recently extradited to Ohio from Michigan. Richmond wasn't able to appear in court immediately. His attorney requested an adjournment to allow time for coordination with upcoming Ohio proceedings. The judge granted it, showing that in complex legal battles spanning states, patience and proper timing are key. Balanced scale spiral calendar justice may be slower than expected, but ensures that every detail is handled properly.
1372, after conversations with Mr. Green, I apparently misunderstood that his client was going to waive the exams based on our conversations. And I let the officer go. I've been out for 20 some odd hours at that point. The officer who was involved in 25 FB 1371 was not here. I don't know if he got notification to come because his partner who was here and they both worked last night. That's why I'm asking for adjournment.
But on 1371,
Yes.
count, just dealing with that case, count 2 is improperly charged, and you couldn't have proceeded today on count 1 because the witness wasn't here. On that matter, Mr. Green's motion to dismiss is granted. I'm dismissing that case.
Thank you, Your Honor.
Now, in the other case, you want me to adjourn it so you can add an account and Mr. Green wants it waived. This one, correct, Mr. Green?
No, I don't. Asking for an exam on this one as well. I'm not asking for a
Today
waiver.
or no?
Beg your pardon?
On case ending in 1372, are you asking for an exam on that one?
No, he's asking for adjournment. I'm asking for a dismissal.
You know, there are some days I'm sitting up here and after a long morning, it feels like everybody's talking French to me. I'm just trying to understand. I thought, Mr. Shepardowski, you indicated that on that case, 1372, that you were considering adding a count 4.
And actually, unfortunately, amending.
Pardon?
And amending count 3. But one of the officers was here. I cut him loose based on our conversations. I misunderstood Mr. Green clearly. So that officer.
And you understood that you thought he was waiving. That's where I'm getting that in my head.
Yes,
But you were going for the exam.
I misunderstood.
That is correct. And it's my understanding. It's also my understanding that there were 2 witnesses that were necessary on this case, and only one was available. So it's my understanding that the prosecutor was going to ask for an adjournment anyway. Is that correct, counsel?
When we started our conversation, Judge, I pointed out the issue.
Because there was
that I
some-
saw with both cases to Mr. Green. And I said, I would like to ask for adjournment on both. We'll get it cleaned up, get it back in front of the court and in court. They know what they're defending against. That's what I initially said, but the officer was still here at the time. And
The officer that's on 1372.
yes, the 1372 officer, who I believe I know I could have gotten through part of the exam. I may have been able to get through all of
Based upon the unreadiness of the prosecutor, I asked for a dismissal on this case as well, Your Honor.
I'm going to deny that request and I'm going to adjourn it because here's the reality. Had there been a meeting of the minds as you need to hands on your pockets. Had there been a meeting of the minds as to what was actually transpiring, prosecutor's position would have been different in that the prosecutor, if you guys had asked me at that moment and the officer were still present, they could start and then I would have adjourned it anyway.
I understand.
Right. So on that case, I will grant the adjournment of the preliminary examination, having dismissed the other one. I will set this preliminary examination for October 21st, 2025 at 9 a.m. That's before me.
Thank you.
Thank you very much, Your Honor. Bond
Thank you.
continue.
Bond continued.
Thank you very much.
Thank you very much.
Court calls the case, People versus Dennis Lane.
Trevor Maybell for the people.
And on behalf of Dennis Link, Your Honor.
Your Honor, the people intend to dismiss this case outright.
Next, the courtroom descended into near chaos with Jimmy Lee Murray's hearing. High voltage, wrongly charged counts, missing officers, and miscommunications left everyone scrambling. The defense requested dismissals, but the judge carefully parsed the errors before making decisions. Ultimately, a case was dismissed while others were adjourned. This clip shows how a single misunderstanding can completely shift courtroom dynamics, and why attention to detail is everything in law. Memo Police Scarlight.
Really? I don't get to yell at Cannon about where her client is?
We can start with that.
Okay.
I mean, we could, but.
Wow.
Your Honor,
But-
I would like to say, I'll take the opportunity for the record to say that this was a relatively minor allegation. Mountain controversy was just barely over $200. It was enhanced to a felony based off of a prior conviction.
Yes.
I had evidentiary issues relating to proving it. It's an older file where once I learned that Mr. Link is currently in custody in Oakland County, he was recently sentenced to 365 days in jail. I believe the interests of justice are best served by dismissing this case today, even in his absence.
And you have no objection.
I have none, Your Honor.
Yeah, had to put emphasis on that. All right, case is dismissed.
Thank you, Your Honor.
You're welcome. Court calls the case, People versus Jacqueline Waitzel.
Good afternoon, Your Honor. Paul Stablin appearing on behalf and with Ms. Waitzel, who stands to my right.
And she's waving.
Judge, we have discussed her rights in regard to a preliminary examination. Ms. Waitzel understands those. She's executed the form about her understanding, Your Honor, and she intends to waive her right to have a preliminary examination, have the matter bound over to the circuit court as charged.
Is all of that correct, ma'am?
Yes, Your Honor.
All right. People also waive their right.
Yes.
Preliminary examination having been waived, defendant is bound over to circuit court on all 3 counts.
In regard to arraignment, Judge, Ms. Waitzel would stand mute. I'd acknowledge receipt of the general information, waive its formal reading. Ms. Waitzel would stand mute. I'd ask the court to enter a not guilty plea on her behalf.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea as to all counts. Pretrial in this matter will be set for
December 3rd at 1:30.
December 3rd, 2025, 1:30 before Judge Conlon.
Very good. Thank you very much.
Thank
Your Honor.
you. Bond will continue.
Thank you.
That's all.
That's all you have.
She's not here.
Yes, no, and I don't have any tea.
Okay. The only thing that I have left then is the coffee banner. The witness, I don't know, how many witnesses were you anticipating on that?
2 or 3.
2 or 3. Okay. I know one of the witnesses is in custody. They are not present currently at the facility here. We were informed that they had a court hearing down before Judge Slay. Because of all of that, we indicated that they could take him to Judge Slay and then come here, and then we would begin. We did that in anticipation that I'd be doing something else, but this is all I have.
Judge, may we approach?
May we approach, Your Honor?
Oh, boy. You may be seated. Court does call the people of the state of Michigan versus Christopher Coffey.
Alex Chabalowski, the people.
Good afternoon, Your Honor. Jay Grant Miller, P58658, on behalf of Mr. Coffey, who approaches to my right.
Good afternoon, Your Honor. Good afternoon. All right, we have been in discussions regarding and I'll just try to summarize it in a way, that regarding this case and some interesting issues that it raises regarding, in this court's mind, ownership, which could lead to, I guess, different conclusions as to how one may conclude the matter.
Dennis Link's hearing took a surprisingly honest turn. The prosecutor admitted the evidence was weak, acknowledging the minor nature of the charge, and voluntarily dismissed the case. Classical building white-heavy checkmark moments like these are rare in court, a true example of integrity in legal practice. Even when cases seem minor, transparency matters. Sometimes justice is about knowing when to step back and do the right thing.
At least view this matter. This court certainly not wanting to render a judgment in error, would think that at least at this juncture, without at least some further discussion, that it is not appropriate to begin testimony. There is because, just so for the purposes of the record, there is a decedent who may have prior to their death, given the defendant a certain piece of property. Were that not the case, or if it's not the case, that property, I think it may be agreed between the parties, would have passed intestate to the two named victims. That may very well mean, and the court doesn't know, that ownership could be a question of fact, or it could mean that there is no ownership until such time as any dispute over that piece of property were settled by the probate court. And certainly I would give counsel time and would hear additional argument as it regards that. And hopefully this matter, since it involves a family matter, can be resolved. But if not, then the court will hear it. But to give time for all of that, everybody's in agreement to adjourn this matter. I'm going to give some additional time because it just scheduled alleged vacations. Well, I say alleged vacations for me. That may happen, as well as the holidays. So I will adjourn this December 1. Okay. I will adjourn this matter to a special time of December 1 at 9 a.m. Council had asked, and I would, and the court believes that's appropriate, so that the individuals aren't coming down here waiting through a docket.
Your Honor,
You're kidding me, man. No, I'm kidding.
I didn't realize that was right after Thanksgiving, and I usually am out of.
December is always right after Thanksgiving.
I was hoping we had that week between and I'd be here, but it's
Is
not.
it? December 15th at 9?
That's fine.
Still after Thanksgiving.
I could do the
But
second.
not so close to Christmas.
I could do the second if it works. It's just the first won't.
Okay, why don't we just
9 o'clock.
I'll do December 15th. All right.
Thank you, Your Honor.
So preliminary examination will be adjourned December 15th, 2025, 9 a.m. That's a special time. That is before me.
Thank you, Your Honor.
And Mr. Coffey, since this is you've talked with your attorney, I'm sure. Did you have any questions for the court as to why the court's doing this?
No, Your Honor. Nope.
You understand?
Yes.
Okay, very good. All right.
And Your Honor, if I may,
Yes.
I'd just like to acknowledge that I'm in receipt of the copies of some text message, and I believe they've been provided to the prosecution as well,
Yes.
that your staff so graciously provided.
Yes.
Thank you, Your Honor.
Thank you. They're a good group of people. They're okay. All right. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
14A. Stands adjourned.
What a wild courtroom ride, from extraditions to confusion, dismissals, and one surprisingly emotional property dispute. First, Dion Richmond's case showed how tangled multi-state charges can get. The defense asked for time, and the judge granted it, a reminder that justice often moves slower than we'd like. Then came Jimmy Lee Murray, and the judge's patience was tested. Wrongly charged counts, missing witnesses, total courtroom chaos. But when the defense motioned for dismissal, the judge agreed, proving that even small mistakes can completely change a case. Dennis Link's hearing brought a different tone, a rare moment of integrity. The prosecutor openly admitted weak evidence and dismissed the charge himself. That honesty is rare and deserves respect. And finally, People versus Coffee, easily the most complex case. A property dispute mixed with family emotion and unclear inheritance rights. The judge's decision to postpone wasn't hesitation, it was smart judgment. When family and law collide, every detail matters. This courtroom session had it all: confusion, compassion, and a reminder that judges don't just apply law. They manage chaos with fairness and a little humor, too.
Finally, the most complex case, People versus Christopher Coffey. Housebroken Heart, a family property dispute intertwined with potential inheritance issues, created a legal puzzle. The judge chose to adjourn preliminary examination rather than rush. highlighting smart, deliberate decision-making. When family, property, and law collide, every detail matters. This session reminded everyone that courtroom decisions aren't just about applying law. They're about navigating life's complexities with care. Balance scale light bulb.